Hi, I'm Fiona Henderson. This week I'm in Albany. I've been in Albany this week preparing witness statements for some lay witnesses in a case. So today I thought I'd talk to you about lay witnesses. In Australia, parties to a court case are required to call as witnesses all people who can give evidence that is relevant to the issues in dispute between the parties. If a witness who is obviously a relevant witness for your part of the case is not called to give evidence, the court can be asked to draw an inference that that witness's evidence would not have assisted your case. One instance where this is particularly important is where the witness is going to corroborate a conversation that took place, because conversations are notoriously difficult to prove. An inference that that witness's evidence could not have assisted your client's version of the conversation can be a powerful inference to be drawn against your client's version of the conversation. The fact that a witness simply does not want to get involved, is away on holidays, or no longer works for you, which is a common one, is not considered by the court to be a good reason not to call them. All witnesses who are physically present in Australia or in New Zealand can be compelled by the court to give evidence, and consideration needs to be given to this where a witness is reluctant to help. In my experience, there are three types of witnesses. There's the witnesses who are helpful, happy to help. There are witnesses who are concerned about upsetting the other side. Often they're in business with both sides on the transaction and they don't want to upset one side or the other. Those can be very dangerous witnesses and need to be handled carefully. And the final witness is the one who I describe as a conscientious objector. They do not want to get involved in litigation, they do not want to help, they don't want to be involved in court proceedings. In Australia, witnesses can be subpoenaed to give evidence. This is an order made by the court compelling them to appear in the court case. Handling a reluctant witness who is only giving evidence under subpoena is dangerous and needs to be handled very carefully. A far better approach is to be creative in your ways to persuade people to help. There are many ways to do that, and often it's simply a matter of explaining the process and explaining what their involvement will be. Overseas witnesses cannot be compelled to give evidence in the same way as a witness in Australia can, and there is an art to convincing an overseas witness to come to Australia to give evidence in court. Sometimes it can be just a question of how you sell it. Creativity can be a really wonderful thing. Until next time.